All right. So morning time. Oh, it's afternoon. Good afternoon, everyone. My name is Danita Jones. Um, can we can you guys hear me okay? All right.
Yes, I can hear you and we can see the presentation.
Awesome. Thank you so very much. Good afternoon. My name is Danita Jones. As Denise indicated, I'm an attorney with Legal Aid Society of Palm Beach County within our Fair Housing Unit. Thank you all for allowing me to be here to present to you about landlord-tenant matters, understanding and navigating the eviction process. As I move on, I do want to say this: in legal aid, we share presentations and share training materials. So I think it's important to give a special thanks to Legal Aid Society, or actually Legal Services of Greater Miami, for allowing us to use some of their training materials within today's presentation. I also want some interaction from the audience. So if you don't mind, when you think of an eviction, what do you think of? If you can put that in the chat and we can talk about it, that would be great. When you think of an eviction, what do you think of? Or what is the definition of an eviction? All right, thanks. I see being kicked out. Anything else? Absolutely, losing your home. Absolutely. So essentially, what an eviction is, it's a legal process through which a landlord can remove a tenant from a property that the tenant is renting. This is not to be confused with unlawful detainer, where you're trying to get that cousin out of your house that you allowed to stay and they overstayed their welcome. This is a process where there is some sort of rental agreement, whether it be verbal or in writing, where the tenant is where the landlord is requesting possession of their property back. And, when we think about getting kicked out and losing your home, that's why we do this work. It has a huge impact on the tenant. If a tenant receives an eviction, unfortunately, that eviction follows them. It's placed on their credit report. In addition to being placed on their credit report, it's also searchable, and they often have to report that they have been evicted to future landlords. And so one of the things that we strive to do at Legal Aid is trying to prevent evictions from happening. Evictions also trap people in poverty and instability. We know that housing and shelter is one of our most basic needs. And without that, it will contribute to a person becoming depressed, and also going through different issues that they may not have had to go through. The eviction process, unfortunately, it's not user-friendly, and most tenants lose without consideration of their cases on their case on the merits. And we'll talk a little bit about the eviction process and what it entails. And of course, now it's one of the leading needs for our clients that are contacting our Fair Housing Unit. We'll go through and we'll talk about the notice requirement, eviction complaints, defenses, motion to determine rent, COVID protections, which no longer exist, as well as I said before, the end of the eviction process. So when we look at evictions, there are a number of reasons why a landlord may choose to evict their tenant. One being non-payment of rent. If a tenant falls behind on rent and is not able to pay. Self-explanatory. Another type of eviction can be based on a lease violation. So if a tenant has a car that's inoperable in the driveway or in a parking lot, then the landlord, if it's in the lease agreement, they can evict based on that. Termination of a month-to-month tenancy. So if a tenant does not have a written lease, they're living there on a month-to-month basis, and the landlord chooses, hey, I don't want you to live here anymore, they can be evicted. And then of course, at the end of a lease term, if the tenant fails to move out. Now, the important thing to remember is that you just can't go in court and file an eviction, nor can you just go in and turn off the lights, turn off the water, and kick the tenant out. There is a process that you have to go through. And the first part of that process is that proper notice must be given. And that's pursuant to Florida Statute 83.56, 83.57, and 83.575. So the first type of notice is a 3-day notice to pay or vacate. That notice is necessary when there is an eviction based on non-payment of rent. You also have a 7-day notice for lease violation. So for instance, I gave you the example of having a vehicle that's inoperable in the driveway or in the parking lot. The landlord must send that tenant a 7-day notice to move that car or make it operable again. If they fail to cure, then the landlord can move forward with filing the eviction. We have a 15-day notice for terminating a month-to-month tenancy. So 15 days prior to the rent being due, the landlord can provide their tenant with a notice of termination. They must provide it, saying that they're not going to allow them to continue their tenancy. 15 days is not a long time the statute requires. Likewise, if there's a tenant that pays on a weekly basis and their tenancy is based on a week-by-week tenancy, then the landlord would need to give that tenant a 7-day notice to terminating their lease before they can file an eviction. When we look at lease expirations, we have to look at the lease language. Some leases are automatically renewed. Other leases require that the landlord gives a 60-day notice to terminate. And then, of course, if the lease terminates, the language within that lease will say something along the lines of it converts to a automatic month-to-month tenancy. So when we're looking at expiration of the lease, it's important to look what the lease actually says. And the lease, of course, can expand the notice requirement. So once we've gotten that notice, the tenant has gotten that notice, and they haven't vacated or done anything about it, then the landlord can move forward with filing an eviction complaint. Evictions are filed in county court. They can be 1-count complaints where the landlord is only asking for possession. We see these in cases where there is a lease violation, or they could be 2-count complaints, which include possession and damages. And we see these a lot, these sort of complaints a lot in non-payment of rent cases, or when a tenant has failed to vacate the property after a lease term, and the tenant is, or the landlord is asking for double rent because that tenant is now considered a holdover tenant. Like with any complaint that's filed, the complaint must be served on the tenant. It can be via personal service, or it can be served, the clerk can mail a copy if personal service is not effectuated. So the landlord-tenant process and landlord evictions fall under summary procedure pursuant to Florida Statute 51.011. Tenant has 5 days to file a response, excluding weekends and holidays. It's a very quick process. When you file an answer to your eviction case, or when a tenant files an answer to their eviction case, or all defenses must be contained within the answer, including motions to dismiss, counterclaims if there are any. You also must be sure to demand a jury trial, and also assert a demand for attorney fees and costs. In some cases, a motion to determine rent is also appropriate. Those are cases where there is a rental amount that's alleged. So most likely your non-payment of rent cases. So one of the common defenses that we see that can be asserted is a defective notice. We see defective notices if the landlord has provided insufficient time in the notice. So remember, I said for non-payment of rent cases, the landlord must give 3 days notice to pay or vacate. Sometimes we see a landlord only gives 1 or 2 days. And remember, the 3 days does not include Saturday, Sunday, or legal holidays. So that also may impact the sufficiency of the notice. If the notice is mailed, they have to add in additional time to account for that, 5 days. If it demands an imprecise amount of rent, or if it includes late fees and late fees are not considered rent, that also can be a defective notice and therefore a defense that can be asserted within the answer. For violations, lease violations, if it lacks specificity or there's no opportunity to cure, again, if the landlord doesn't give 7 days to move that inoperable vehicle, then of course, the tenant can assert defective notice. And if the language doesn't substantially comply with the statutory notice requirement. The good thing is, if there is a defective notice, good thing for the tenant, if there is a defective notice, the case must be dismissed without leave to amend. There is an exception for cases involving evictions for non-payment of rent, in which case the landlord is given an opportunity to cure the deficiency in the notice or pleading before the dismissal of the action. Yes. So I have here for some more interaction between you guys, an example 3-day notice. Take a look at this 3-day notice, and if someone can type in the chat, what do you believe is, if there's any deficiencies, and if there is a deficiency, what is it? Give you guys a couple of seconds to do that. Do we see anything here? Absolutely, it's the notice date. If you look here at the bottom of the notice, it shows that the notice was actually served. This is a 3-day notice to pay or vacate. At the bottom of the notice, you will see that the notice was served on May 15th. However, if you look, it also says that they demand the rent or possession of the premises within 3 days, but they kept the May 15th date. So this would be a defective notice, and there can be a defense asserted. Thank you. Other common defenses: a waiver, accepting rent with knowledge of non-compliance. You waive the eviction. Now, if for non-payment of rent cases, the landlord can accept rent after posting the notice if it provides receipt, deposits the rent into the court registry, and serves a new 3-day notice, and so it wouldn't waive it. But for the most part, if you are accepting rent, then there is a waiver. Sorry about that. Another common defense is failure to maintain the premises. The tenant is required, however, in order to assert this defense, to send a rent withholding notice demanding repairs within 7 days. A lot of times after an eviction is filed, the tenant will come back and say, well, there's mold in my apartment, but there was never notice sent to the landlord. Retaliation is another defense. So of course, a landlord will get upset if a tenant complains to code enforcement or complains about a condition, but they cannot retaliate against that tenant. They cannot evict the tenant based on those complaints. They cannot increase rent, and they cannot decrease services. Retaliation is a defense to any eviction. Another common defense is improper party. The landlord means the owner or lessor of a dwelling unit. So if I don't own a unit, I can't evict you. I think, that's pretty general knowledge, but it's something to look out for because we do see a lot of it. The plaintiff is not the proper party in the lawsuit. A lot of times it comes when there's a corporation that owns a property and the president of that corporation files the lawsuit in their name. Corporations without an attorney. Remember, a corporation, unlike a natural person, cannot represent itself and cannot appear in court of law without an attorney. So if there's a corporation that's appearing in court without an attorney, we can, or has filed a lawsuit without an attorney, that can be asserted as a defense. Property managers can file complaints for evictions and motions for default final judgment and writ of possessions and uncontested residential evictions for non-payment of rent. However, in order to do that, they must have authorization from their landlord. And then finally, another defense is payment. Hey, I've paid my landlord, and so therefore I should not be responsible. I should not be evicted. And we do see more and more of these as there are several rental assistance programs that are out there where the tenant or the landlord has been paid. We talked about the rent deposit requirement. In addition to answering the case, the tenant must also do one of the following within the 5-day period. So they must deposit the rent alleged in the complaint plus court registry fees. They must assert payment as a defense, or they must file a motion to determine rent if they're contesting the amount of money or the amount of rent that's owed. Important. Failure to comply with the rent deposit requirement waives all defenses, and an immediate judgment for possession without a hearing is very likely will happen. So within a motion to determine rent, it's best to attach documentation to the motion to show. So if you've paid, you can show receipts of payment. A hearing is probably required. The tenant must continue to deposit rent as it comes due. So if that case extends for 6 months, the tenant must continue to put the money into the court registry. This is an example of a motion to determine rent, a pro se motion to determine rent, which was filed by a tenant facing eviction. It does cite several issues with the home, repairs needing to be made. Unfortunately, one of the things that I realized here is that it does not include a rent withholding letter. It doesn't show like that, that there has to be, that the rent was paid, doesn't talk about communications. So it's important to watch out for this. If there's a rent withholding letter, they should have attached it. You don't have to attach it, but it's good to attach it. So over the last year and a half, there have been several eviction moratoriums that have been in place. The most recent was the CDC's temporary halt on evictions. That CDC halt is no longer in place. The Supreme Court found that it exceeded its statutory, its purposes. The CDC exceeded its statutory authority. But with the CDC's temporary halt on evictions, basically it halted evictions for people that, for non-payment of rent cases. In order to have, in order to get protections under that CDC's declaration, the tenant had to submit a declaration asserting that they met the conditions of it. But again, unfortunately, we no longer have that protection. Previous to the CDC's halt on evictions, there was the CARES Act, and then Governor Ron DeSantis also had issued an executive order. But currently, there are no protections against evictions, and therefore, landlords are unfortunately filing them to remove tenants from their property. So we look at the eviction case progress. If there is a pending motion to determine rent, most judges will require that be resolved first. Then you would go into mediation. After mediation, if a settlement cannot be reached, then parties can engage in discovery. The court will hear a motion to dismiss if there is one, and it could also proceed to trial. Remember, you have to demand a jury trial within the answer if that is what your client wants to do or the tenant wants to do. Once an eviction is pretty much after the trial, or if there's no trial and there's no answer filed, then a final judgment for possession, will be entered. The clerk will issue a writ of possession, and a writ of possession basically says, sheriff, please remove the tenants from the property. When the sheriff gets that notice, they will put it on the door. It's a 24-hour notice. And it happens extremely, extremely quick. So what we like to let clients know is, hey, if you know that there's a writ of possession coming, go ahead and remove some of your most valuable items. If you can't get everything out, try to get some sort of storage, try to get a moving truck, just try to get out of there, because that morning when the sheriff comes, essentially your items will just be dumped on the side of the road. And we want to try to prevent that from happening. There's no exceptions for health, weather, or children being in the home. Unfortunately, if the writ is issued, the writ is issued. Some issues to consider: a tenant with an attorney immediately changes the dynamic, because an attorney can let that tenant know, hey, we need to file an answer. We need to make sure that we're filing the motion to determine rent. We need to make sure that we're meeting the deadlines under summary procedure. Our goal is often to get more time for the tenant. If we can get more time, then for non-payment of rent cases specifically, it gives them more time to try to pay back the money that's owed. As I mentioned before, we have a number of rental assistance programs that are available. And we have a contract with the county to help with those rental assistance programs. And also it'll allow them more time to return to work. I'll talk a little bit more about the program that we have at Legal Aid that helps with emergency rental assistance. As we know, moving is expensive, and affordable housing, unfortunately, is very, very hard to find. One of the things that we also want to make sure is avoiding a final judgment. That's very important. So if a tenant can move out of the property, if the eviction is for possession only, they move out of the property, we can try to avoid that final judgment from being entered against the tenant. Security deposits, you can talk to the landlord to see if they would be willing to allow the security deposit to be applied to past due rent. A lot of times landlords will not agree with that, but that is an option in order to try to buy more time. And something to look out for, and we see more and more now, are prohibited practices. When we talk about prohibited practices, we're talking about landlords that are turning off lights, turning off water. Those are prohibited practices. If a landlord does that, then the tenant can obtain 3 times of the monthly rent from that landlord. So I had a case in the past where literally the landlord turned off the water. He said, tenant's not paying rent, so why should I provide the water? The water was a part of the lease agreement, and that was completely wrong. And so that tenant was able to recover 3 times the monthly rent. Our rental assistance program at Legal Aid, we have the Rapid Response Eviction Assistance Program. It is exclusively deals with landlord-tenant issues. We try to work with the county in order to get money to the landlord on behalf of the tenant so that they are not evicted. We try to do pre-suit settlements type of cases, pre-suit settlements, so that evictions are not filed and not searchable in Palm Beach County records. We also help with pre-suit mediations between the landlord and the tenant. And we also have other referral rental assistance programs that are available. So the county's program allows rent to be paid to US citizens. Legal aid has an in-house program that allows payment to undocumented persons as well. So we're trying to cover everything, everyone who have been impacted by COVID. So other programs, we have our Fair Housing Project. We represent clients who have been discriminated against and that are a part of a protected class. Our Community Economic Development Project also helps people living in Riviera Beach, Boynton Beach, Lake Worth Beach, Belle Glade, Pahokee, and South Bay. And we have our Elder Law Program that helps clients who are 60 with a variety of legal issues, including landlord-tenant matters. So as attorneys, we can make a difference. You can make a difference. Our courts were never intended, this is from Justice Thurgood Marshall, our courts were never intended to serve as a rubber stamp for landlords seeking to evict their tenants, but rather to see that justice be done before a man is evicted from his home. And so again, it's important to make sure that we're asserting those defenses that are available. If there's a counterclaim for a prohibited practice, that we're asserting that as well. And that a person is just not put out on the street.
Great. So this is the perfect segue to talk about the Pro Bono project. So hello, everyone. Thank you so much for letting me join you. I am Melissa Kellner. I am an attorney with the Pro Bono project at Legal Aid Society of Palm Beach County. And I am here to just give you a really quick overview of Pro Bono and how you can get involved. So if we go to our next slide. Okay, so a little history for you. In response to a need for legal services, the Supreme Court of Florida adopted the voluntary pro bono plan, which is actually part of the rules regulating the Florida bar. And this plan requires that all Florida bar members report annually their pro bono work, which is, even if it is 0 hours, you have to actually fill that out. And the hope is, I think, to shame people into maybe doing pro bono work, whatever works there. And part of this rule actually established a goal for every attorney to do at least 20 hours of pro bono work a year or donate at least $350 to a legal aid organization. So for Palm Beach County, the Legal Aid Society of Palm Beach County is the designated agency for administering the Florida Pro Bono plan. Okay, so the Pro Bono project at Legal Aid, we handle our campaign for equal justice. So every year we send out a request for participation to attorneys throughout the county, and we ask every attorney to either volunteer as a pro bono attorney or to make a financial donation to legal aid. So these forms you should receive throughout the year via mail, or you can also access it anytime by going to our website, or you can reach out to legal aid and we would be more than happy to send it to you. So anyone who is interested in doing pro bono work with legal aid, you must fill out this form and send this in. So this next slide here is going to show you what our campaign for equal justice form looks like. So hopefully this looks familiar to you, but if not, this is the campaign for equal justice form. And as you can see, it is very simple, very fast to fill out. You just provide some basic information. And then if you look at this attorney information form, this side here, this is where you'll actually be able to select which areas of law you are willing to take cases for. And so what happens is you mail this back to us, and then we are able to input this into our system. And then when we get a case needing a pro bono attorney, we can go into our database and we can actually filter by subject area and find the right fit for the case, and hopefully have a pro bono attorney who's able to assist a client in need. So a little additional information for you. Legal Aid is able to provide pro bono attorneys with mentoring and training whenever needed. So if you are accepting a case and you have any questions at any time, please feel free to reach out. We are here to help you help us. So another thing is, if you are interested in doing more of some sort of team project, we're happy to coordinate creating some sort of specific project for instance, a firm or voluntary bar association. So in the past, we have done these projects where there's been groups handling either basic wills or expulsion and guardian advocacy cases. And so whenever we create one of these projects, we would be able to provide CLE training for you and get you all the information and templates, if applicable, to make it as easy of a process as possible. And then the other main thing we want to make sure everyone is aware of is that if you do handle a pro bono case with us, you are covered under our malpractice insurance. So huge point to remember. And that is really it. So if you have any questions, feel free to ask, or you can reach out to me at any time and I would be happy to discuss further any questions you may have regarding pro bono work. All right.
All right, so thank you so much, Melissa and Danita, for that presentation. You are able to get a CLE credit for this presentation, and I will put that CLE information up on the screen now. So if you would like to record that information down, the CLE credit number is 2006339N. And I will copy this into the chat as well.